Namaskar, this is Seshadri, your level advisor, corporate trainer, post IC member. It gives a lot of pleasure to meet you through this video. This video is HR statutory complaints for the month of 2025 August. As well as this video consists of a judgment received during July 2025 as well as the circulars received in July 2025. I'm very happy that you are watching the video as well as giving the comments. It gives a lot of pleasure to give more content. Please watch the video till end and then definitely it will be helpful to you. Please share this video to all our HR fraternities. Let us start with the one quiz. There are two questions. Question number 1. An adult worker, if he is earning 15 days leave in a calendar year, that means you take 2024 he earned 15 days leave and then he is having the credit of 20 days in his calendar, in his leave credit. And then 1st January 2025, as per section 79, please note the point, as per section 79, how many days you can carry forward to 2025? This is the question. Answers are 15, 20, 30 and 35. Please think over it about section 79. The second question is probation. You want to extend the probation of one of your employee. Whether is it necessary to mention the reason while extending the probation? These are all the two questions. Please think over it. Let us see all the content, then we will see the answers also. Statutory complaints for the month of August 2025. There are two complaints in this month, PF and ESI. PF, we need to pay on or before 15th August 2025 for the month of July 2025. As well as international workers returns also we need to file August 15, 2025. ESI, same compliance for the month of July, we need to pay the challan on or before 15th August 2025. 15th August is holiday, so please plan accordingly. Trainings, this month we have very good and innovative trainings, full day trainings, direct trainings at Vellore. This month we plan. Legal compliance, if you start a business or any organization, factory or shop and establishment, what are all the compliance you need to do from the starting of scratching of applying the licenses, what are all the forms, what are all the returns, social security, PF, ESI, bonus, and then POSH Act, everything is going to cover. That is going to happen at Vellore on 23rd August. As well as online session, 2 sessions we are having online full day sessions. One is in Tamil, that is 24th August 2025, training and development. How you can identify the training needs of the employees, that is a skill, either it may be a skill matrix or whatever the methods you can use to identify the requirements of the employees, how to make the calendar, how to make the approval, budget, how to conduct, and then feedback, return of investment, everything, modern techniques, everything you are going to see on training and development. And then 31st August we have another session, code on wages. This session will be going to analyze all the provisions of the code on wages which is going to come, as well as how it affects other areas also. That also we are going to see. This session will be in English. All pan-India people can join in this. Next, CPI points, if you see, there are little increase from 339 to 342, little increase in the CPI points. Let us see the important judgments. First judgment on POSH. The boss, who is the male employee, the subordinate, she is a female employee. During the meeting, along with the colleagues, they are sitting. The boss is telling about her leave, and then she is not performing well. What are all the gaps? Is keep on telling. So the female employee feels it is a humiliation, as well as this comes under POSH. It is a sexual harassment. That's what her complaint says. And then it has come to the Telangana High Court. Finally, High Court clearly defines what is sexual harassment, what is not sexual harassment. This is a very good case. And then it has clearly said, by asking the targets, asking the gaps, it is now humiliating. That will not come under POSH. That's what the clear indication given. And Gujarat High Court, one very good case about the ESI coverage. One factory is there. That factory is constructing another premises. Buildings construction is going on. For that, whatever the payment has been made, for that ESI has to be paid. That's what the ESI corporations demand. And then it went to the Gujarat High Court. Gujarat High Court properly analyzed and said that is a process, that is a separate place, as well as the manufacturing is not yet started. That time ESI coverage will not come, as well as the construction person is having the code, so he has to take care. That clarification has been given by the honorable court. And then when you are having the contract employees, you cannot unilaterally change the service condition. You have to discuss mutually, only you can change. That is the Delhi High Court's judgment. Rajasthan High Court has given very good one judgment about the withdrawal of resignation letter. The employee sent the resignation first day. The second day he thoughts, and then he wants to withdraw, and then he sent the letter through certificate of posting. The employer did not receive that post. The employee argues, I have sent, so I can continue. The employer says, no, you have just submitted the resignation, more than that, nothing. Finally, Rajasthan High Court analyzed, and then there is no evidence from the employee. That's why whatever management action is correct. That's what the judgment. And then Bombay High Court has given good judgment on the inquiry. In this case, factory employees, did not come to the work months together. The management is asking them to report, but they are not reporting. Finally, they removed from the roles, and it was come to the court why domestic inquiry has not been conducted. Bombay High Court given, when the employees voluntarily they are not coming to the work, abandoning the work, so they are not there is no need for domestic inquiry. That's what the Bombay High Court. Usually we face lot of cases like this. When the people are not reporting for duty, we used to send a lot of letters to the employees, but they did not respond. We can't conduct a domestic inquiry for them, so it is a very good case law for us. And then Madras High Court, again another same gratuity case. The gratuity we cannot distribute on monthly basis. When gratuity falls due, a lump sum should be given. In this organization, they arranged one pension scheme against in lieu of gratuity. They are contributing in the pension scheme. The employee will get month on month like pension like that in lieu of gratuity. That is not correct. That's what the Madras High Court judgment. It should be a lump sum. And then Delhi High Court's another judgment, the employee cannot be prevented from joining another. Yeah, it is very good case. In our appointment letters, we used to mention, you cannot join with the so and so company, you cannot join with the competitor since you are handling the confidential or something data like that. We used to mention whether it is correct or not. Delhi High Court again, it is earlier also. This many case laws are that we should not mention like that, because it is a fundamental rights of the employee. They can work, they can do any business anywhere in India. We cannot control which is the right given by the Constitution, as well as the Indian Contracts Act section 27 also it is violating. So we can't put like that condition. That's what the Delhi High Court's judgment also says. Very breaking big amendment has come in Bihar. What you see in Factories Act, they have amended. What they amended? They amended the daily working hours from 9 hours to 12 hours. Sometime back when the courts were introduced, we were keep on discussing about the 4 days work and 3 days holiday. Yes, it is practically silently it is implemented in Bihar. Section 54 has been amended from 9 hours to 12 hours, as well as section 55 from 5 hours once break has been amended to 6 hours once break. As well as section 59 OT, what is the hours beyond the hour is OT. Per day the employee works more than 9 hours or weekly 48 hours, that will be treated as OT if 6 days pattern. In case 5 days pattern, 10 hours more than 10 hours as well per day, for more than 48 hours per week, that will be treated as a OT in case of 5 days working. And 4 days week, that is the 12 hours working hour per day. In that 11.5 hours, if the employee works more than 11.5 hours as well as weekly 48 hours, that will be treated as OT. This is a very new thing from Bihar government. It is new for everyone for us. And then section 65 that gives how many hours quarterly we can do overtime. It has given 144 hours in quarterly they can do overtime. That's what the great amendment from the Bihar government, as well as one assurance we have to take a concern letter from the employees in case if they want to do overtime as well as they want to work 12 hours. This is provisions which is given in the labor codes. Already now Bihar government has implemented. So it is a first state to go for 12 hours working hours. Earlier some of the states like Andaman Nicobar, Andhra Pradesh, they have amended to 10 hours, but 12 hours this is the first time I hope. Another big news is that is Prime Minister Vikasit Bharat Rozgar Yojana. In that, both the employers and the employees are going to get incentive. The first time employees who are coming for the job, they are going to get the up to 15,000 rupees as an incentive. For that, there is some problems also there. Employers are going to face some problem in UN generation, and the employers are going to get around 3,000 rupees per employee when they are generating more employment. So this scheme was launched on 1st August 2025. Because of that, in addition to that, there is a one circular on 30th July regarding the UAN generation. UAN generation is possible. The first time UAN generation is possible through UMANG app only. No one can generate that is by the employer. They can't generate in the employer portal, only through UMANG app. That is the circular is saying. Before that itself, the UMANG app are equipped to generate UAN as well as activation as well as face authentication. Because to get the incentive, this is very essential. The government is going to transfer the incentive amount directly to the employees through Aadhaar based account number. Whatever number it is connected with the Aadhaar, those account number they are going to set. So the activation is very essential, mandatory. That's why they have come with this proposal. They will only employee can generate, not an employer. And this is based on the condition is gross wages. It should be below 1 lakh for that incentive. Details are available in this channel videos. What is the incentive as well as what are all the incentive schemes, and because of UAN generation, what are all the problems employer going to face, as well as solution also I have given. You can watch this description box. I have given the link, as well as how to create UMANG app in UAN in UMANG app. That also given. All the videos are available in Tamil, English and Hindi. So we need to mention gross wages in ECR, that also given in this circular. Another amendment that is a great news from Tamil Nadu. Factories portal, that is dish portal, has been migrated. That migration, every employer again they have to re-register it, and then they have to brought back all the information to the new website, that is server. For that, detailed video has been given Tamil and English. Anybody is having factories, that it is immediate and the essential mandatory. You have to do the migration to avail all the services of the factories, that is dish. In Tamil Nadu, Catering and the Establishment Act has been little amendment. It is not a big amendment. As well as when the establishment you are going to register, you have to attach the photograph of your front face of your establishment. In that in Tamil language, you should have written the company name in big letter. Already it is implemented. Shop and Establishment Factories Act also. Rajya Sabha, one question has come. What about the labor codes? In Rajya Sabha, they have stated very clearly what is the status of the labor code. There are 32 states already drafted draft rules. Only West Bengal and Lakshadweep, they did not drafted any of the rules, that codes they did not made. And then Tamil Nadu, for Social Security Code, they did not made any rules. This is a status, as well as for the gig worker, platform worker, those for them Social Security Fund to be created, that also pending. That is the status given in the Rajya Sabha. Karnataka Welfare Board, Labor Welfare Board, they have given the pamphlet. In the pamphlet, up to 35,000 who are drawing, the employees are eligible to get the facilities. One good thing is I could be able to see the for maternity also they are giving 10,000 rupees. This not I hope it is not in other states. It has given in the Karnataka. Maharashtra state, they have come forward to cover the education institution as well as medical institutions under ESI. So all the people who are working in those institutions, they have to be covered under ESI. ESI, they have announced the spree scheme. Everyone knows from July to December the scheme will be in exist. That means in case any of the employer who is employing more than 10 employees and they need to cover ESI, but they forgot, they did not cover in various reasons. Now without inspection, without any penalty, they can come forward and then cover their establishment under ESI through spree scheme without any audit also. And some of the states again they come forward with the rules for employing women employees in night time. Already few states last few months they have implemented. Now it is time for Uttar Pradesh as well as Odisha and then Himachal Pradesh. All the states they brought, as well as Punjab, they have announced who is the authority to decide under section 6 of 1 of B under Factories Act, which only gives the empowering the people who can decide can employ about the employing women in night shift. That will be the labor commissioner come director of factories, he will only going to decide. These are all the contents for this month video. The answer for the quiz is, first quiz answer is 30. You may be amazing how 30, because the question very clear. Under section 69, what is the maximum? Under section 69, 30 days is the maximum. If the as a welfare, if you want to transfer 20 plus 15, yes, it is good, but as per 69, maximum is 30 days only allowed. This question number 2, mentioning the reason for extending the probation. Yes, you have to mention, because what is probation? Bombay High Court's one judgment has very clearly said what is probation. This is the thing which management can assess the suitability of the employee. So if you want to extend, you must mention the reason. Hope this video would be helpful to you to improve your knowledge. Kindly comment what are all the things you want, or you want to improve in this. Any mistakes also you can comment on the comment box. We'll get back with another video, good video for you. Please share this video to all the HR fraternity. Thank you for watching. We'll get back with another video. Thank you.